Hello, my dear students. Welcome to Grade Up, India's largest online education platform. I'm Vinod Shankaran. And in today's video, we will discuss critical reasoning sample questions as given in CLAT consortium. Okay, this is discussion on paper number 3. I'll show the passage, okay, or you have the PDF. Read the PDF, check the answers, and check the explanation. Okay, listen to the explanation that I give you. Okay, so read the passage in your own at your own leisure. Read it, okay, and then give the answers and check the answers with the video. Now, these CLAT consortium released the sample paper on the 16th of April. You know that, okay. Then this is the sample paper 3. Okay. Now, this is the passage. Now, what we need to do is read, understand, and then answer the questions. Okay, if you don't want to read from the screen, you don't have to. You can keep the PDF and read it from there. You can also look at the answers given there. Okay, understand how the questions function and how the answers have been given. कैसे question कैसे लिखा गया और answers कैसे दिए गए. Okay, both you can see from there. So let's go to the questions and then I'll tell you. Okay, the passage was about exclusionary covenants. Okay, the passage that you read was about exclusionary covenants and how, and the author says how this is discriminatory and how the courts have been able to find a way to ensure that exclusionary covenants don't become discriminatory. Okay, covenants are orders or unwritten orders. Okay, so exclusionary covenants, orders or rules, laws that are exclusionary, that doesn't include everybody from the society. Okay, so having said that, read the passage at your own leisure, understand the passage and understand these 2 points, that the passage is about exclusionary covenants and how the courts have found a way to keep this outside the purview of the agreements. Now this is in terms of non-movable properties, immovable properties. Okay, so which of the following would be an example of exclusionary covenant as described by the author? Now, to answer such questions, logical reasoning questions, as I've told you in other videos also, it's very important to understand the question. The question is half the time it is the answer. Because if you have understood the question well, then you know what you're going to focus on and you can find the answer. And then things like knowing some terms. What is inference, what is assumption, what is weakening statement, and what is strengthening statement, etc. Okay, once you know those concepts and you know that the question is more important than the answer itself, because if you understand the question, then most of the time you have also framed the answer in your mind with the passage. Okay, now read the question and then understand. Which of the following could be an example of an exclusionary covenant as described by the author? Which of the following could be an example? So if all these are examples, then which of the one would qualify as an exclusionary covenant where some discriminatory actions are taken within say a contract? Okay, so let's read one by one. Okay, what is the answer? Okay, let's read one by one. A provision in a rent agreement for a residential apartment which states that the tenant may not use the apartment for any illegal purposes. Now it says discretionary, not unlawful. Okay, no, so this is not an exclusionary covenant, this is a legal covenant. This is something that must be ensured. Okay, so this is not an example of exclusionary covenant. This is an example of a legal covenant. Okay, it's a legal thing. Nobody can use it for illegal purposes. This is not discriminatory on the basis of religion, caste, etc. Okay, now to the second one. It is true for everybody. Okay, then a social media website where people can view each other's photographs whose terms of service prohibit persons belonging to a certain ethnicity from becoming members. Well, this again does not relate to immovable properties. Exclusionary covenant has been specifically given in terms of immovable properties. not about things that are, say, that which cannot be touched. Okay, intangible kind of properties. Okay, so it doesn't talk about that. So even if it is true, then it is because it does not talk about immovable properties. Therefore, exclusionary covenant will not be applicable here. Even if it is discretionary, it will not apply to exclusionary covenant, because there is the word exclusionary covenant has been used for something that is immovable. Okay, now come to the third one. A provision in a contract for the sale of a property which specifies that the seller would only hand over the property to the buyer upon receiving the full sale price of the property. Now, this is the essence of the contract. When I'm selling something, I require my money. Okay, the sales proceeds to come to my hand, and I have to receive the entire amount before I can write an agreement. That is not discretionary. If I say, if you don't pay the full amount, I'll not hand over the property. So this is not exclusionary covenant, in the sense it is not discriminatory in terms of religion, caste, etc. Okay, so C is also not the answer. So we have eliminated three. The fourth must be the answer. Let's read the fourth also. Okay, the answer is D. Okay, so a provision in a rent agreement that provides the apartment would not be rented to persons belonging to a certain religion. Now this is an exclusionary covenant. Come to the next one. Which of the following is the author of the passage least likely to agree with? What will he not agree with? What will he not agree with? So let's read the first one. Exclusionary covenants are bad because they provide restrictions on the basis of matters that are normally considered discriminatory. This he will agree with. This is the essence of the passage. This is what he's trying to say. This he will agree. Okay. Least likely to agree, disagree is what we are looking for. Exclusionary covenants are bad because they make matters difficult for people who until recently have been formally treated as second-class citizens in law. Okay. Now this also he will agree. Okay. Exclusionary covenants are bad because they make a contract very difficult to understand, read and understand. Okay. That's also. Okay then. Now come to the third one. Exclusionary covenants are bad because they make a contract very difficult to read and understand. Now this does not make an exclusionary covenant bad because you cannot read it and understand it. This is a very personal kind of, this is a personal thing. Okay, some people can understand, some people cannot understand. The language is very complex, does not really mean that this exclusionary covenant may be bad. Okay, so this he will disagree with. Then the last one, exclusionary covenants are bad because they fall at the intersection of the private right of contract and public evil of discrimination. Okay, you have your right, private right to contract. Okay, and then there is that public evil of discrimination. Now that falls in between these two boundaries. Now if that happens, then it's very difficult to understand whether this exclusionary covenant is actually happened, this discrimination is happening or not happening. So this also he will agree with. Okay, the only thing he will not agree with is the contract has been written in complex language. Okay, but that does not necessarily make it discriminatory. Okay, so all the other terms are very good, but only then the language is too tough. But that does not make it discriminatory. So he'll disagree with C. Okay, then which of the following is the author of the passage most likely to agree with? Now what will he agree with? Then there will be three statements which he'll not agree with, and he'll agree with one. Okay, solutions to the problem of housing discrimination have to be found in creative manners by courts. Now this he will agree with. Okay, this he will agree with. Therefore the answer is already there, but let's check. Let's not be in a hurry. Solutions to the problem of housing discrimination have not been achieved anywhere in the world. He will not agree with this because he says there is a way we can do this. Okay. Then solutions to the problem of housing discrimination can only be achieved by changing contract law. This also he doesn't say. He says within the ambit of what we have now, we can still achieve, we can still keep out exclusionary covenant. Okay. Housing discrimination is not really a problem, and the courts need not try to find a solution for it. This also he'll agree with that. He says the courts have to find a solution also. They have to be creative, he says, within the ambit of the current law. You don't want a new law also. Okay, so you'll agree with 3A. Right, then let's go to the next question. Let's go to the next question now. The author describes 3 creative solutions that courts in countries that broadly respect freedom of contract while also enshrining a constitutional guarantee of non-discrimination have come up with to solve the problem of housing discrimination. Which of the following is not such a solution? Not such a solution. Now, this is why I tell you, reading the question well and understanding the question. If you do not see this one word, you may get it wrong. Which other one is not a solution? Now, courts refusing to give effect to a contract that provides for housing discrimination. Courts refusing to give effect to a contract that provides for housing discrimination. This is not. This is a solution. He says if courts do this, this is a solution. If courts do this, then exclusionary covenant, that is the discrimination, can be kept out. Now, courts invalidating a contract that provides for housing discrimination. Now, this is also stated as a solution. Courts imposing steep fines. Fines has not been mentioned. Has not been mentioned. So this is not a solution. This is not a solution given by the author. Therefore, the answer is C. None of the above is not possible. When C is the answer, none of the above is not possible. Now, which of the following situations is most similar to troublesome legal problem posed by exclusionary covenants as described in the passage? Now, tell me which one is most similar. Which one can also be an example of troublesome legal problem? We don't have to talk about posed by troublesome legal problem posed by exclusionary covenants. Okay, so talk about troublesome legal problems arising out of exclusionary covenant. Okay, which can also be an example. A law passed by Parliament which provides for discrimination on grounds of religion in matters of citizenship. Okay, now if this happens, then it is not a troublesome legal problem. It's not a troublesome legal problem. Why can you say that? Okay, because if it is provided by the law itself, there is no legal issue because the Constitution has allowed it. Okay, which provides for discrimination on grounds of religion in matters of citizenship. If this has happened, then you're bound by the Constitution, so you don't have to worry about it. So this is not a trouble. This is not a trouble because this is provided for in the Constitution. Second one, a private company which states that it will not hire as employees persons belonging to certain castes. Okay, now if this happens, then this is troublesome legal problem because the Constitution does not allow discrimination for jobs, etc. But this company is doing it according to its private contracts. Okay, so there is that the private contract and the public good. Okay, and it falls in between. So if that happens, it's a troublesome legal problem. So B is the answer. B is the answer. Now, a shopkeeper who refuses to open their shop for business on certain days of the week. Now, that is their own prerogative. They can do it. It is not discriminatory. It's not discriminatory, not a legal trouble. That is their own wish. They can open it or close it. A restaurant that serves only vegetarian food. Again, not a legal issue. Now, these are things which are my preferences ensured by the Constitution. Ensured by the Constitution. Okay, and if the Constitution itself adopts a rule, a law which says, okay, an article which says this is possible, a law passed by the government which provides discrimination on grounds of, if the Constitution itself allows a discrimination, then the courts have nothing to do. Okay, they can just interpret the law as it is passed. Okay, then, so a private company which states that it will not hire employees, here the problem will be the government and the private company Both have their, the country has its own constitution and the company has its own contract. And in the middle falls the discriminatory ground. That will be a troublesome legal problem. Okay. Which of the following, if true? Now, this is very important to understand this. If true is something to be taken as true. Now, these statements must be taken as true. Don't say that these are not mentioned in the passage. This will not be mentioned in the passage. You have to assume that these are true. And then say, will most weaken the author's argument in the passage above. Weaken the argument. Now, this must be understood. What do we mean by weakening an argument? Okay, weakening an argument is somewhat like this. Suppose you have an argument. An argument is nothing but what the author wants to say in a passage. Okay, he has got a conclusion. Let's put it this way. He has got a conclusion and he bases it on some premises. Now, these premises are the pillars. Okay, he has based it on pillars. Now, the conclusion, the argument has got solid base. The conclusion and the pillars, both of them are together called, the premise are called the pillars. Okay, the pillars and the conclusion together form a good solid structure. Now, I want to weaken it. Now, I want to weaken it means what should I do? I should be able to break the pillars. Okay, shake the pillars and make sure that the pillars fall. If the pillars fall, then the conclusion will also fall. Okay, so I have to have a strong counter argument. So what are the counter arguments? What do you think can be the counter arguments which will shake the foundation of the author's conclusion, author's argument? Okay, so let's understand. Groups that received formal discrimination as second-class citizens until recently are provided strong rights upon receiving legal emancipation that prevent use of exclusionary covenants against them in contracts. Now, the author says that courts have to find. See, that is the first thing to understand. What does the passage say? Only then I will be able to shake that. I have to understand the pillar on which it is standing. Okay, the author's argument was that the courts must find ways to step in between and make sure that discrimination doesn't happen in terms of exclusionary covenants contained in a private contract. Okay, the courts must step in and find a solution. Read the A. If this is true, then what will happen? Suppose this has been ensured by the Constitution itself. The Constitution, suppose it has given the second-class citizens, okay, they have been given strong rights upon receiving legal emancipation. They have been given legal freedom that prevent the use of exclusionary covenants. That is, exclusionary covenants just cannot even be thought of by a private contract. Okay, so if I have exclusionary covenants and I go to the court will throw it out, simply saying this has been ensured by the Constitution. So you have it is illegal. What you are doing is illegal. So go out. Okay. So here A is something that will weaken the argument. If this has been done already, if this is already a law, then what the author offers as a solution is not even necessary. If this be true, then the author's solution, the entire passage is a waste. You don't have to write it. I already have the right. Okay, so therefore A will weaken the argument. Okay, don't even have to read the others. But let's check. Groups that received formal discrimination as second-class citizens until recently continue to suffer discrimination. Now, in which case the courts must step in. Okay, groups that received formal discrimination as second-class citizens until recently often encounter bias and fear. Here also, they have to step in. Okay, here the court has to come in to play. Here the court has to come into play. They cannot throw the contract out because it is something that the contract is violating, but it is very much within the legal ambit. The law doesn't say anything about it. Then, so groups that face discrimination and bias through informal means or may not also suffer formal discrimination as second-class citizens. that face discrimination and bias through informal means may or may not also suffer from formal discrimination as second-class citizens. Now, whatever happens here, whether it is formal or informal, okay, they are suffering some kind of discrimination, and there the court must step in. Okay, so the role of the court is applicable to 3 cases and not 1. This will weaken it because the author says the courts have to step in, and this solution, if this were true, then the author did not even write the passage. Which of the following most accurately represents the author's argument in the passage above? Now, what is the primary purpose of the passage? Here, most accurately represents means what is the purpose of the passage? That is, you have to give the conclusion and the problem. The issue and the conclusion must be given. There is a problem discussed and there is a solution given. Both must be part of this primary purpose. That's why he sat down to write. Okay, so let's see. Exclusionary covenants are wrong because there is no way to prevent private rights overruling public guarantees. No, there is no way. No, he gives a solution. Exclusionary covenants are wrong because they lead to the formation of ghettos. Again, formation of ghettos, this is not given in the passage at all. Okay, now. Exclusionary covenants are wrong because they encourage division and distrust among groups. Now, this is also not, this is only one part of the problem. We are talking about courts coming into play. Exclusionary covenants are wrong because they perpetuate forms of discrimination that have been prohibited by law. This is correct. That have been prohibited by law. Okay. Then to the next question. To the next passage now. Sample questions on page number 2. Now, passage number 2. Now read this. Take your own sweet time. Read the passage. Come to the conclusions. Or read the answers also. Check what you answered and what the CLAT consortium gives, and listen to the explanation in the video. Now, what is the main point in that passage about? Now, this is about the Constituent Assembly. Okay, a body called Constituent Assembly. Okay, now Constituent Assembly. Okay, which though was not representative of the entire British India, was still able to discuss matters which was in the best interest of everybody. Okay, that is the main point. We are talking about the Constituent Assembly. It was not well represented. It was not well representative of British India. Even though that happened, still matters that was of the best interest for everybody in the country, okay, were discussed freely. That is what we have to say. Okay, so what is the answer to this? The Constitution Assembly included a disproportionate number of representatives from the Indian National Congress. This is not given also. Okay, even if this can be guessed from that line where it says Indian National Congress actually enjoyed a majority when Muslim League left. Well, even then the second part is not there. That is, they were able to function in a very unbiased manner. Okay, the Constituent Assembly included a disproportionate number of representatives from the princely states. Again, the second point is not being discussed. The Constituent Assembly provided opportunities for debate and different viewpoints, even though it was not broadly representative of the population of British India. Exactly what the author is trying to say. That the Constitution Assembly was not broadly representative of British India and thus did not have any legitimate authority to frame the Constitution. This is exactly what opposite of what the author is trying to say. The conclusion is there, but it is the exact opposite of it is exactly the opposite of what the passage is trying to say. Which of the following, if true, would most weaken the author's argument in the passage above? Weaken. Again, I have to shake the foundation of the conclusion it is standing on. Okay, so what was the basis on which it is standing? It says, though it was unrepresentative of British India, yet it was able to discuss and deliberate on matters of interest to everybody in the country. Okay. So what will most weaken the argument? Okay, so That is, such a thing was not good for India. Such a thing was not good for the Constituent Assembly. That is what you have to say. Counter-argue the author's point. Merely presenting opportunities for debate and differing viewpoints is not enough to provide legitimate authority to frame the Constitution to the non-representative Constituent Assembly. Now, this will not shake the foundation. We have to shake the foundation. That is, they were able to discuss. Now, this is merely represented. Just by giving opportunities, nothing will happen. Now, that is your point of view. You're not shaking the author's opinion, author's basis on which he has said that though it was unrepresentative of British India, still it was able to discuss and frame clauses which was in the best interest of everybody, so that it does not shake it. Then, as a body that was not broadly representative of the adult population of British India, it was impossible for the Constituent Assembly to have provided opportunities for debate and differing viewpoints. This is very much a possibility. If this happened, then what the author is saying is incorrect. If this is true, suppose we take this to be true, then if this happened, because it was unrepresentative of the population of India, so a handful of people, okay, taking all the decisions on behalf of all the others may not be a good idea. Now, if this happens, if this had happened, then the author's view is wrong. Okay, so B is a possibility. It is not necessary for the Constituent Assembly to have been broadly representative of the adult population of India for it to have provided opportunities for debate and differing viewpoints. Now, this is what the author is trying to say. This will not weaken it. This will strengthen the argument. This will weaken the argument. Okay, this will neither weaken nor strengthen it. This is something not related to the argument. It is not related to the argument. Now, the Constituent Assembly was within the control of the Indian National Congress, but did not provide opportunities for debate and differing viewpoints. Okay, now if this happens, it is not okay. The Constituent Assembly was not completely within the control of Indian National Congress. Now, even if this happened, this will not weaken the argument, because the author says it was not representative of the British India. Now, just because it was within the control of Indian National Congress, okay, but it did provide opportunities for debate. Now, if this happens, then this will also strengthen the argument, right? This will also strengthen the argument. Therefore, B is the correct answer. B is the only one which will strengthen the argument. Weaken the argument, sorry. B is the only one which will weaken the argument. Now, to the 10th one, which of the following can be inferred? Now, whenever we say inferred, if you have watched my other videos, you will understand that we are looking for something that is probably true and not mentioned in the passage, or definitely true but not mentioned in the passage. Okay, you have to make sure that you understand which of the following statements are probably or definitely true according to the passage, and the passage does not explicitly mention it. Inference means an implicit conclusion that can be drawn, and the implicit conclusions must be probably true or definitely true, which are not written in the passage. Okay. Despite having an overwhelming majority in the Constituent Assembly, the Indian National Congress did not prevent the articulation of opposing ideas. Now, this itself is probably true. This itself is probably true. Okay, that's why the author says they could discuss things, and that the Constituent Assembly was largely successful, because and the Indian National Congress had majority. And he doesn't say that Indian National Congress did not step in the way of discussions, etc. It does not say that, but then it can be understood. So first itself could be the answer. Let's look at the second one. The Indian National Congress used its overwhelming majority in the Constituent Assembly to suppress any viewpoints. Now, this cannot be. This is probably false, because the Constituent Assembly was successful. Third, the representatives of the princely states in the Constituent Assembly frequently disrupted the Assembly's proceedings. This is also probably false. because ultimately the Constituent Assembly was successful. The exit of the Muslim League ensured that only one voice in the Constituent Assembly was that of the Indian National Congress. Well, this the exit of the Muslim, this has been directly written. This is directly mentioned. This is something that is not implicit, it is explicit. This is directly given in the passage. So it cannot be the answer for your implicit, which is implicit must mean probably true or definitely true, which is not mentioned in the passage. Okay, therefore the answer is A. Okay, then to the 11th one. If the author's arguments in the passage above are true, which of the following is also likely to be true? That is, if we take everything that the author has written in the passage to be true, then which also must follow? Okay, now this is again an inference, because we are trying to find a conclusion which is not explicitly mentioned by the author, and you have to find one. Then therefore this is also an inferential question worded differently. Again, we are looking for a definitely true or a probably true statement. The Constitution as drafted by the Constituent Assembly does not represent viewpoints of the Indian National Congress. Now, does not represent the viewpoints of the Indian National Congress. This is probably true, because though they had a majority, they let it function very on a very balanced manner, okay, unbiased manner. Therefore, first itself could be the answer. The Constitution as drafted by the Constituent Assembly largely represents the viewpoints of the princely states alone. Probably false. Okay, this conclusion cannot be drawn. This will be the opposite of what the passage says. The Constitution as drafted by the Constituent Assembly is not representative of a variety of different points of view. Probably false. The Constitution as drafted by the Constituent Assembly is representative of a different variety of viewpoints. Okay, now this is also possible. So which one is the answer? Which of the following are likely to be true? The Constitution as drafted by the Constituent Assembly does not represent the viewpoints of Indian National Congress. Or D, the Constitution as drafted by the Constituent Assembly is representative of a variety of different points of view. Now you will see, because we have stuck in two. Go back to the first one. Now here this is probably true, but then we did not think it fully. The problem is, whatever viewpoint was ultimately brought out as the Constitution was also representative of the Indian National Congress. So we cannot say it does not represent. It does represent it, but it's not the viewpoint of only Indian National Congress. Therefore, this is also probably does not represent as probably false. If I had said only represents, then this was definitely false. Okay, and okay, if I say it does not represent, then this is not probably true. This is probably false, because it does represent. It represents everybody. So Indian National Congress also comes into it. Okay, so and then the D, the Constitution as drafted by the Constituent Assembly is representative of a variety. Now here Indian National Congress is also included. Therefore D is the correct answer. Okay, at times you get stuck in two options also. Then you do thinking once more. Okay, check it with the data and check the two options that you have. Okay, try to compare the two options that you have. Then you get the answer. Now, which of the following, if true, could be a reason why the Constituent Assembly emerged as a remarkable forum for the articulation of intellectual disagreements and contrasting viewpoints, despite the limitations identified by the author in the passage above? Could be a reason. Okay, so the rules of functioning of the Constituent Assembly provided that all groups, no matter how small or large, had adequate voting power to ensure they had a voice in the Assembly's decision making. Now, this must be true for the result to come out that way. That is, emerged as a remarkable forum for the articulation of intellectual disagreements and contrasting viewpoints. If you wanted that, then the author says it was not representative of the British India. The membership was not representative, but still it was possible. That means the voting on a particular issue was equal. Okay, everybody had the same amount of rights. Okay, so this first one is true. Okay, and A is possibly the answer. Let's look at B also. There were a number of procedural safeguards in the manner in which the Constituent Assembly worked, which ensured that all groups, no matter how small, had a chance to air their viewpoints. Now, this is also true. So, both A and B must be the answer. C is the correct answer. Okay. Now, which amongst the following is following most accurately explains why the Muslim League decided to boycott the early sessions of the Constituent Assembly? What could have been the reason? Let us take a guess. Okay, let's take a guess. Within the within the realm of the passage only. Okay, we will not bring outside information. Why would they have wanted different Constituent Assembly? Okay, they felt that Indian National Congress was biased in favor of the Muslims of the country. Now, if this was done, then why should they have bothered? Okay, if Indian National Congress was biased towards Muslims, then they need not have bothered. They did not want they did not require a constituent assembly, a separate constituent assembly. Okay, so this is probably false. They felt that it would be best if different constituent assemblies were constituted to draft constitutions for two different countries, because there are two different countries based on two different values. Okay, two different values. Therefore, they wanted a different constitution assembly. This is probably true. They felt that the Constituent Assembly only represented the interests of landholders. Large landholders from which place? India or Pakistan? Okay, so this does not this is neither the reason, may not be the reason. We do not know. The data is insufficient to take a call whether this was the reason. Now, they felt that they would be able to draft a better text for India than the other members of the Indian National Congress. No, they would be thinking about Pakistan. They will not be thinking about India. Okay, so this is also probably false. So the answer is B. That is all for this session. Okay, thank you all very much for watching this video. Target CLAT 2020 is a course that GradeUp has come up with for your CLAT preparations and law exam preparations. It's a score up course. Okay, Target CLAT 2020, 100 plus live classes. Okay, for the new CLAT pattern with interactive quizzes, 3,000 plus practice questions. Then we have 12 mocks for IELTS, SLAT, MASET, BALLB 5 years 2020, and top quizzes and PDFs for revision, full coverage of current affairs and legal knowledge. Okay, this is the YouTube schedule. You can keep it. You can keep a note of this and attend the YouTube schedules. These are free, therefore you can attend these classes. If you have already done preparation from somewhere, then you need not prepare again. Okay, then you can actually follow this YouTube schedule. You can tell your friends. You can ask them to also join in. Do subscribe to our YouTube channel and press the notification button to get all the notifications and the new videos as they are uploaded. Okay. Thank you all very much for watching this. I'm Vinod Shankaran, and we will meet in the okay. Thank you all very much. Keep following GradeUp, prep smart, score better. Thank you all very much. Bye bye.